Coming up on second session, Judge Aquilina sentences a defendant who admits he's a horrible monster when he drinks. Judge McNally weighs sobriety court for a different defendant. And Judge Prill hears a motion to end a personal protection order. Ellie's excited to get started, so let's head right into court. Good day, everybody. Welcome to second session. My name is Dan. It is good to have you here. We're going to start with Judge Aquilina, and this is the sentencing of Paul Tucker. Now, we first saw Mr. Tucker sometime back, 3 weeks ago, on the morning show, and he is returning now for sentencing, so let's give that a look.
All right, this is docket 263871FH and 2295FH. People of the State of Michigan versus Paul Tucker. Counsel, your appearance for the record.
Good morning, Your Honor. APA Barb Buxton on behalf of the people of the State of Michigan.
Aaron Robinson, Assistant Public Defender for Mr. Tucker.
Sir, please raise your right hand. Do you swear or affirm the testimony you're about to provide to be the truth, whole truth, and nothing but the truth under penalty of perjury?
Yes, Your Honor.
Thank you. Put your hand down. Have you taken any medication yesterday or today?
No, Your Honor.
Are you supposed to be on medication you're not on?
No, Your Honor.
Any sign of fever, COVID, or other illness?
No, Your Honor.
You've had an opportunity to speak with your attorney?
Yes, Your Honor.
And you've been satisfied with your attorney?
Yes, Your Honor.
All right, very good. And today we moved it from, a day or two ago. It was a long week, I don't even remember. But this week we moved it so that we could bring up your new file and have that information so that there would be what everybody terms as a global resolution. So you didn't have to come from multiple things at different times. So it appears to me that there has been a resolution, and I just signed the plea agreement, and copies will be coming to all of you. Is that correct?
That is correct, Your Honor.
It is, Your Honor.
And sir, do you live on Dorchester when you're not in lockup?
Yes, Your Honor.
And who lives there with you?
Amber Davy.
And well,
That's the victim in this case, Your Honor, and she is on Zoom right now.
okay, so she is the victim here. So do you understand there's a no contact order? You can't live with her?
Yes, Your Honor.
Okay, so if and when you're released, do you have a different place you can live?
Yes, Your Honor.
And where is that?
We at 2906 Creston Avenue.
Preston?
Yep, C-R-E-S-T-O-N.
C-R-E-S-T-O-N. Is that Lansing?
Yes, Your Honor.
Who lives there?
That'd be my father.
Did you know the zip code?
48906.
All right, and do you and Ms. Davy have children together?
We do not.
Okay. And do you have your things in that Dorchester home?
I do.
Okay, so we'll have to figure out a way for that to be transferred to your father's home. But you're not allowed, there's no contact order, so you're not allowed to do that.
Understood.
Okay, thank you. And you're a US citizen?
Yes, I am.
And you committed this offense that you'll be pleading to while you were on probation with me, is that correct?
That is correct.
Were you on probation anywhere else?
No, Your Honor.
So you understand there could be a probation, a punishment on probation in regard to this other file?
Yes, Your Honor.
And I don't have the copies are just being made. Okay, do you all have your copies?
Yes, Your Honor.
Okay, just handed mine. So let me see, was there a resolution as to the violation?
I believe he pled, Your Honor, to the probation violation, but we held sentencing in advance to wait for this file to come up.
Correct.
All right. Okay, thank you. Okay, behalf of the people, what is the plea agreement?
Yes, Your Honor. Mr. Tucker will be pleading to added count 2 of domestic violence, second offense notice. Upon successful plea and sentencing, count 1 domestic violence, third offense should be dismissed.
And the victim was consulted?
Your Honor, yes, I had a chance to talk to her this morning. I know the prosecutor in district court had a chance to talk to her, and she's present via Zoom right now.
Is that full, fair, accurate, and complete?
It is, Your Honor.
Is that full, fair, accurate, and complete, sir?
Yes, Your Honor.
And counsel, you're waiving reading, count 1,
We are.
as to the reading of count 2.
Yes, Your Honor. People of the state of Michigan versus Paul Allen Tucker. State of Michigan, County of Ingham, in the name of the people of the state of Michigan, the prosecuting attorney for this county appears before the court and informs the court that on the date, not the location described below, the defendant in an added count 2 domestic violence and or knowingly assaulting a pregnant individual, second offense notice. On or about October 19th, 2025, at 1153 Dorchester Circuit, apartment 201, Lansing, Michigan, 48910, Ingham County, in the state of Michigan, the defendant did make an assault or an assault and battery upon Amber Davy, a resident or former resident of his/her household and/or an individual with whom the defendant had a dating relationship, contrary to statute. Second offense notice. Take notice that the defendant is previously convicted of assaulting or assaulting and battering his spouse, former spouse, an individual with whom he had a dating relationship, an individual with whom he had a child in common, or a resident or former resident of his household, or of knowingly assaulting a pregnant individual by violating MCL 750.81 subsection 2 on or about December 10th, 2013 in the 65A District Court, County of Clinton, State of Michigan. And therefore, conviction will be subject to an enhanced sentence under statute. That sentence being 1 year and or $1,000. If the assault was committed in a place of confinement, the court may order the sentence for this offense to run consecutively to any sentence the defendant was serving or to the sentence for the offense for which the defendant was being detained per statute. And against the peace and dignity of the state of Michigan.
And is this going to be a guilty plea or no? Last time he pled no contest. This is going to be a guilty plea.
Yes, Your Honor.
All right, thank you. Sir, did you understand what was just read?
Yes, Your Honor.
So you understand count 2, domestic violence, second offense is a misdemeanor punishable by 1 year and or $1,000, and there's restitution that also must be paid if the victim is asking for any restitution for property or personal damage or loss. If you disagree with the amount, we'll have a restitution hearing and I will decide the amount. The amount can go up, it also can go down. Do you understand that?
Yes, Your Honor.
All right, thank you. And it looks like you signed the advice of rights form. Did you read it before you signed it?
Yes, Your Honor.
Did you understand what you read?
Yes, Your Honor.
And if you had any questions, your attorney was able to answer those?
Yes, Your Honor.
Do you have any questions about your rights of this court?
No, Your Honor.
Sir, as to count 2 and the amended felony information, domestic violence, second, how do you plead?
Guilty, Your Honor.
Do you understand that by pleading, you're giving up your automatic right of appeal? If you choose to appeal, you first have to ask permission of the Court of Appeals to appeal. As you had a bench trial or jury trial, you would have an automatic right. Court of Appeals would have to take a look at it, but now it becomes their decision as to whether or not your issues are important, and they will only take your issues up if they agree with them. Do you understand?
Yes, Your Honor.
And you understand that by pleading, you're giving up your right to a bench trial or jury trial, presumption of innocence, the ability to hold the people to the burden of beyond reasonable doubt. You don't have to prove anything at all. And you're losing the ability to cross-examine any witnesses or evidence and bring any witnesses of your own, etc. You understand all those rights you're giving up by pleading.
Yes, Your Honor.
And has anyone told you what I will do at sentencing?
Yes.
Yeah, what did they tell you?
I was told that I was possibly going into treatment.
Well, you possibly were, but nobody made any promises as to what would happen, is that correct?
That is true, Your Honor.
All right, and so you understand that I'll make up my mind after I listen to what everyone has to say.
Yes, Your Honor.
All right, very good. Sir, did this offense occur on or about October 19th, 2025,
Yes, Your Honor.
in the city of Lansing County, of Hingham, state of Michigan,
Yes, Your Honor.
at a specific location known as 1153 Dorchester Circle, apartment 201?
Yes, Your Honor.
You lived there with Amber Ray Davy, the victim here?
Yes, Your Honor.
And did you and she have some kind of argument?
Yes, Your Honor.
And were you intoxicated or high?
Yes, Your Honor.
Which?
Both.
And do you remember the events that you're talking to me about today?
Yes, Your Honor.
And did she do something that angered you so that you touched her inappropriately?
Yes, but it was still uncalled for.
Okay, so what happened? What did you do to her?
I pushed her out of my way, and then doing so, I ended up stumbling and falling into a shelf full of soups. And then afterwards, I picked up a can of soup and I threw it at her.
And did it hit her?
Yes, it did.
And you did all of that out of anger and also because you were intoxicated and high?
Yes, Your Honor.
And you understand being intoxicated and high is not an excuse to injure or assault another person.
I do, Your Honor.
And what you did to her, both initially and then after you fell, was not done in self-defense, is that correct?
That is correct.
And sir, you previously were convicted of domestic violence on or about December 10th, 2013 in the 65A District Court, County of Clinton, State of Michigan.
Yes, Your Honor.
So you agree that this would enter as a second, and that's why.
Yes, Your Honor.
All right. On behalf of the people, any additional questions?
People are satisfied, Your Honor.
On behalf of your client, any additional questions?
Just briefly, Your Honor, Mr. Tucker, did you have a previous romantic relationship with an Amber Davy?
Yes, Your Honor. I'm sorry, yes.
Nothing further.
All right. I don't know if I asked you this. Do you have children in common? You don't.
We do not.
All right, thank you. On behalf of the people, are you aware of any promises, threats, or inducements other than those already placed on the record?
No, Your Honor.
On behalf of the defendant,
No, Your Honor.
has court complied with the court rule?
You have, Your Honor.
It has.
I find defendant's plea has been freely, voluntarily, knowingly, and understandingly made without undue influence, threats, coercion, or promises of leniency. I also find there are sufficient grounds to accept defendant's plea. Therefore, count one is hereby dismissed. Count two will enter. The domestic violence second, which is a 1-year misdemeanor. Any outstanding warrants related to this file and the other file that we're here today on, which is the 2295FH file, are hereby recalled and dismissed, if any. And it doesn't look like there was any contraband seized, but if there was, that would also be forfeited. And maybe go into immediate sentencing.
September 16th.
No, immediate sentencing.
As the victim is here, the people would not have an issue with that, Your Honor.
And we have no objection either.
All right, thank you. On behalf of the victim, Ms. Davy, did you wish to address the court?
Your Honor, my understanding based on my conversation with her is she did not wish to do so, but I'm not sure if that has changed.
I am seeing her shake her head no. Well, and you can just nod your head to this question as well, ma'am. Is there any restitution that you're seeking for any personal or property damage, loss, counseling, anything like that? She's shaking her head no. All right, is there a mutual person that you can box up his things and get those things over to his father's house?
I think you might need to give her permission to unmute.
She needs it. Can you give her permission to unmute?
Okay. Unfortunately, I already gave his friend Lindsey the chance to come get his stuff.
Okay, that's fine. Did she come get it?
No, she never showed up. Everything was outside for her to pick up, and maintenance threw it away while I was at work.
Okay, did that include his IDs or any important papers? Do you have any of those things?
There were no court papers sent.
Not court papers, I mean like driver's license or anything like that. Does he need to, because if I send him for treatment, ma'am, I need to make sure he's got an ID. What's his ID?
He's not in my property.
ID should have been in his wallet.
Okay, just making sure birth certificate or whatever wasn't also thrown out.
He did inform me, Judge, that his ID is in his property at the jail.
Thank you for being here. If there's anything else you want me to know, just wave your hand now. I'll call on you, okay, man? I appreciate you being here.
Thank you. I did give his phone to the prosecutor at the last thing to give to his attorney, so he could have that.
Okay, very good. So you have your phone, sir. All right, thank you. Thank you for letting us know. All right, on behalf of the people, what would you like me to know?
Yes, Your Honor. Obviously, Mr. Tucker is still on probation in the 22 matter, Your Honor, that is also in front of Your Honor. I was not here for the probation violation hearing where he ultimately pled for failing to report to probation. But I do see in the notes that you were looking to send him to some kind of residential treatment for alcohol. I will say, after looking at his criminal history, it's very clear that Mr. Tucker has an alcohol problem. I'm seeing a history of both operating while intoxicated as well as domestic violence from 2010 until now, Your Honor. So this is an individual that very clearly needs counseling in regards to both his alcohol and his anger management. So I do believe that if the court is to continue him on probation and not revoke him, I would ask Your Honor that he go to a residential treatment for alcohol and do counseling that involves intimate partner violence and anger management. Thank you.
All right, thank you. In regard to probation, what is your recommendation?
Thank you, Your Honor. For the 22 file that he's on probation for, ultimately, I would recommend revocation as he never reported probation and now he has a new conviction for the exact same crime. However, if Your Honor would be sentencing probation and an immediate sentence, then you could, the treatment I've looked into on your behalf that is available to be TRICAT and any number of days you would wish to order up to 150 days. But I would recommend revocation on his prior probation file and to continue his 365 jail sanction. But again, ultimately I'll defer to the court's discretion. Thank you.
Thank you. And as to the people, your recommendation on that other file as well?
I would defer to probation, Your Honor. Thank you.
Counsel, if you could address both issues.
Yes, Your Honor. I think in this case, I agree with the people that Mr. Tucker has an alcohol problem. And it's clearly night and day from me reading the police reports to when I meet with him and talk to him. And while he's been in jail, he's been pretty pleasant and very easy to get along with individual. And I think it just shows the impact that alcohol and drugs have had on the system. I understand in this case, in the probation matter, he was originally placed on probation and he didn't do anything. I mean, that shows that he really hasn't had the opportunity for treatment, not giving him an excuse or anything of why, he decided that he was going to skip out on probation. That was clearly not the correct call. But, he didn't get that opportunity to get treatment. And I'm not sure if, a stint in jail, up to a year in jail is really going to do him any good, because by the time he gets out of jail, he's just going to be back on the streets drinking again. Without having any proper treatment to that. So I would ask the court to sentence him to keep him on probation for the probation file and to sentence him to a term of probation for this file. Allow him to be PR to a treatment program, a long-term treatment program that would address substance abuse issues as well as anger management issues for him. Speaking with Mr. Tucker, he's very open to that. He wants treatment. He's never really had treatment before, and he's definitely open to it. He wants intensive treatment. He wants to put this behind him, and really just able to be sober and enjoy his life. So we would ask the court to sentence Mr. Tucker to a term of probation followed by a time in treatment program, then followed by a term of probation.
Sir, what would you like me to know?
I have been battling alcohol for most of my life. As what my attorney says, I am a pleasant person when I'm sober, but I'm a horrible monster when I drink. And I just really want a chance at doing long-term treatment and just getting my life together. That way this never happens again.
Pretty much told me the same thing a couple of years ago. I'm looking at my notes and I'm looking at, and you admit to being a violent person when you drink. This is a rerun of a couple of years ago. So why do you drink? How old were you when you started drinking?
I was around 15 or 16.
And what, you drank because it was cool, and then what happened?
I started drinking because it was cool, then kind of just one thing left that, went after another and just got out of control by the age of 20. I think there might be some abandonment issues in there as well.
You said that because it's very clear you've got some other underlying issues. So who abandoned you? Parents, mom, dad?
Yes, my parents.
Where are they?
Well, my mom basically walked out of my life when I was 2. My dad, he's currently upset with me, but he's came around a little, and my grandmother that has raised me passed away about 6 years ago.
Okay. Your siblings?
I do.
So you're in contact with them?
No.
Is it because of your drinking?
Me and my brother, we just don't see eye to eye. He has his own problems as well as I have my own problems, so.
Okay. All right, and that might very well be a good decision. So I'm gonna put you on probation for 2 years. That's 24 months. You shall not use, possess, consume, purchase, or be in the presence of alcohol, illegal drugs, or drug paraphernalia. If you have a need for any of those things, you will present a prescription from a licensed medical physician within 24 hours. You will serve 365 days jail. And the file I'm talking about right now is the 265871 FH. We'll get to the other file in a moment. You'll serve 365 days jail with, how much credit does he have on the new file? Does anybody know?
Honor, it looks as though he was arraigned on looks as though he was arraigned on July 18th. Not sure if he was in custody the entire time or not, however.
Were you in custody the entire time?
Yes, Your Honor.
Since July 18th?
Yes,
Does that
Your Honor.
sound right?
July 17th is when I was arrested.
Okay. Okay,
And I would agree with that, Your Honor. This wasn't in custody.
That's what I have as well.
all right. Anybody can count the days? $21 days?
21 days is what I have as well.
All right, so you'll have 365 with credit for 21 days. You will enter TRICAP no less than 90 days, and depending on how well you're doing, you can stay up to 150. And then I will hold the rest of the jail in abeyance, and you'll do probation. So you have 24 hours to report to probation, at which time you will wear a scram tether for no less than 90 days. Probation can extend that if you're not doing well. If you are doing well, then we can consider removing that. You will be in treatment for grief counseling, and substance abuse treatment will be continued. And you will also do 90 in 90, meaning you will attend 90 days straight of AA. If you miss a day, you'll start over. So 90 and 90. Now, I've had people try to be creative and do 3 meetings in one day. That stuff counts as only 1.
I understand that.
Okay. And then, as long as you're doing well, then we'll move it down to 3 times per week. And then you can move it down as you're doing well, but I would like to see you go at least once a week. It really does help. And by the end of those 90 days, I want you to have a sponsor who has been clean and sober, gotten that way through a program. And they've been clean and sober for at least 5 years. If you need more time than the 90 days, work it out with probation. But I think that you should be able to find someone to go to a regular meeting and you engage with people. You do seem like a great human when you are not intoxicated. So I have every reason to believe that you will be able to find someone to be your sponsor. The scram tether, if you can't afford it, hopefully there's a grant that allows for that. If not, we'll talk about it. You will also, looks like you worked at Valvoline. I don't know what else you've done recently, but you certainly have some skills and you can get a job. So you will be employed within 30 days of your release, and if not, you'll be part of a receipt program or sooner if you work that up probation. The counseling will also include domestic violence, the intensive program, and that will include cognitive behavioral. You'll sign all necessary releases so we can verify that you're doing what you need to do. You will obey all court orders and recommendations from all treatment providers. That includes any therapist, probation, doctors, whoever. If you're supposed to do something in a program, that becomes an order of this court. It's not optional for you. It might be optional for somebody else, but not for you. So show up on time, participate, and that's why you're signing the release. We're never going to talk about your personal matters, what you said to a therapist, but we want to know if you're following the recommendations. Same with doctors. Doctor's recommendation is an order of this court. You will not have verbal, written, electronic, or physical contact without permission of probation with anyone known to have a felony record or to be in the commission of a crime. That includes in the Michigan Department of Corrections, someone on probation or parole. If you need contact with anyone like that, you will first get permission from probation. As long as everyone's in good standing, that's fine with me. You'll not use any object as a weapon. You'll not own, use, have under control or area of control a weapon or imitation of a weapon. No guns, no ammunition. You'll not use any object like that can as a weapon. Can is not generally a weapon, but can be a weapon. So anything that could be a weapon, you're not allowed to use it like that. Does that make sense to you?
Yes, Your Honor.
You have 24 hours to contact probation upon your release. So if it happens on a Friday, we have until Monday. If Monday's a holiday, it would be Tuesday. All right. You'll report any prescriptions that you're taking the same way within 24 hours. You'll comply with allowing probation into your residence at any time for probation supervision without a warrant, and subject to a search of your person and property, including but not limited to your vehicle, residence, cell phone, and computer. If there's reasonable cause to believe that items that might violate the conditions of your probation. You must report any arrest or police contact, personal protection order placed on you, loss of employment or change of residence within 24 hours. Weekends and holidays are accepted. Again, something else on Friday, tell us on Monday. Monday's holiday, tell us on Tuesday. You will reside with your father. If for some reason you find out that you cannot live with him, you need to let the program know and your probation agent know, and we'll figure out whether you go into a sober living house or there's lots of different options. If you end up being homeless, then you need to tell us each and every place that you're, every shelter you're at. So if you're at a different one every 10 days, you contact probation, let them know. You will not have any contact with Amber Ray Davey, AMBER RAYE DAVEE, or Stephanie Allen, directly or through another person. You'll not be within 500 feet of the residence, school, or place of employment. No contact means no contact. We've had this conversation. Don't get creative. Don't send any Hallmark cards, messages through third parties, smoke signals, carrier pigeon messages, phone calls. I don't care how you think you can communicate through a third party. Don't do it. You end up with the same Myers, you do an about face, and you go to a different one. You end up with the same church service, you leave, you go to a different one. Do you understand?
Yes, Your Honor.
And you don't make any gestures. You don't even wiggle in here. You just do an about face and get out of there. Do you understand?
Yes, Your Honor.
You'll pay a $50 state cost. I'm sorry, it's yes, it's a $50 state cost and a $75 crime victims assessment. So it's $125. You have until the end of probation to pay that. I'm waiving probation oversight fees, finding that you're indigent for that. You will not use recreational marijuana or alcohol unless you have a prescription, and then you'll follow that prescription. You can use over-the-counter medication. You can use less, but not more. Sir, the women in your life deserve roses, not bruises.
I agree.
That's the sober you talking. You need to have a little chat with yourself. In whatever state you're in, there is no excuse for being drunk, high, and violent against anyone.
I understand, Your Honor.
I have 2 women here. I suspect in your life there have been others. You cannot leave a trail of broken women behind. I am very proud of both of these women for reporting and sticking to it. Many women don't. But sir, if this doesn't stop, you'll be in prison. And you're lucky that can did not hit her on her temple or her heart or some vital organ where she stopped breathing and died. Is it worth it?
It's not, Your Honor.
Then you have to do everything in your power to stop harming others. It is only a weak man who strikes a woman. It is only a weak man who then uses alcohol and drugs as an excuse and hits their women. So it is not cool, it is not acceptable, and it is dangerous. As to docket 2295 FH, just how much jail time does he have? I know he's got 10 days and then probably these 21 days. I don't know if we did any others.
I believe it's just the 31 days, Your Honor.
All right, so I'm just gonna give him 31 days of credit for 31 days and closed unsuccessfully. He did nothing. He's gonna be dealing with this one file, sir. And then any monies that are owed on this will be transferred to the other file.
And Your Honor, probation would ask that you be held pending placement at TRICAP.
Yes, he's going to be held until he, until there's dead. Yes, absolutely. So you'll get the extra jail credit days. And then, you have to complete that. So you'll get a PR bond as soon as there's a bed available, and then there's transport. So I don't know if TRICAP picks you up or the jail takes you there. Either way, you're not leaving jail. You're going from jail to treatment, and then your father's home. And you'll be on that scram tether.
I understand.
Anything else?
Nothing further, Your Honor. Thank you.
No, Your Honor.
Sir, good luck to you. Let this be the last time you assault someone. Let this be the last time you're in jail. Let this be the last time you have a hangover.
Clear.
You've played all your cards. Your deck is empty. Leave the table. Do good in the world. It's all for the record. Oh, no. You have 42 days to appeal and to request appellate counsel. Please give this appellate rights.
We don't have any paperwork over here, and I
Oh,
don't
we'll
see
get you one.
any over here as well, so.
Okay, so we're gonna get you those appellate rights. There is a newer one, but.
Thanks.
To acknowledge receiving your appellate rights, sir, you have 42 days to appeal and to request appellate counsel.
Okay.
Do you acknowledge receiving that?
Sorry?
Do you acknowledge receiving that?
Yes, Your Honor.
Sir, good luck to you.
Thank you.
And, oh, wait, let me just, I don't want to go over it again. There is a no contact order. You acknowledge also that you understand that, correct?
Yes, Your Honor.
That also means no phone calls from the jail, no phone calls from your father's house, no phone calls from treatment. You understand that?
Yes, Your Honor.
And I don't care if the women show up at your father's house, they know you're out and they dance naked around his house. You call 911. You do not answer their phone calls. You do not open the door. Do you understand that? Because I hear a lot of blaming the victim because they showed up. Don't do that. Just don't open the door. Got it?
Understand, Your Honor.
Thank you. That's all for the record.
Greetings once again, everybody. Second session on this lovely Tuesday. I'm going to take you next to Judge McNally. He also has somebody that he's dealing with who likes to drink and isn't particularly good at it.
How did I let this one get by? Jeffrey Vance. People against Jeffrey Scott Vance, 267-703-966.
Good morning, Your Honor. William Mays on behalf of Mr. Vance. Mr. Vance, state your name for the record, please.
Jeffrey Vance. So, a couple things.
Yes.
Thought we struck this, didn't we? It says if the defendant is terminated from sobriety.
No, you struck that.
Well, oh yes, I did. Thank you.
Yeah.
I wasn't sleeping that day.
No.
You still got your work cut out for you on this one. I want you to understand.
Yeah.
He's fleeing and eluding. He's got a third offense. He's got a 267. He's been very good.
Oh, yeah.
I've enjoyed having him, but I'm just telling you, you got your work cut out for you. Have you had a chance to review this report and a recommendation with your client?
We have.
Any material additions, corrections, or deletions?
No corrections or deletions, Your Honor. We're asking him to be admitted to the sobriety court.
All right. What else would you like to tell me, Mr. Mays?
No,
I
think that he's going to be a good participant.
I'm
in the
just
sobriety court program
telling
this
you,
week.
I'm inclined to send him to jail is what I'm trying to tell you.
Oh, well, you shouldn't do that, Judge. The whole point to sobriety.
You don't have to lecture me
I
about
know.
the point to sobriety court. The point is, he had a 267.
Yeah.
He was fleeing and eluding the police. And
Well,
this,
it's
hang
illegal.
on, whatever. You get my point.
Yeah.
You got a good deal for him. He hasn't had one, I'll grant you, in 16, 17 years, but he had one in 2000, one in 2009. And I don't like the conduct on this particular date with a 267. So you don't want to say anything else, you don't have to.
Judge, I don't know if there's much else to say. I mean,
I got it.
This is, the whole point of the sobriety court program is to offer these incentives and disincentives And he's shown himself to be amenable to this type of a program. I mean, this is one of the rare exceptions where a person is clearly not doing this to get their driver's license back. Because I mean, I think that at worst, he was looking at a 30-day suspension as opposed to a revocation. This is a person who's embracing the sobriety court program. So he's made those proactive steps. Insofar as the fleeing and eluding, I mean, the truth of the matter is that when a person is intoxicated, the police are specifically trained to look for a person who has no response or delayed response and all that. The prosecutors want to drop the fleeing and eluding. They were all tore up over that, so they gave us the attempt. My opinion is, this is my personal opinion, that the drunk driving is more, important in this.
Well, of course it is.
Yeah, and addressing the underlying substance abuse issue is the more important issue in the case, and that's exactly what he's doing. I mean, so the whole idea of recidivism and getting the proper treatment is what permeates the whole sobriety court program doctrine, and that's what Mr. Vance is doing. So I would ask.
I appreciate you,
Yeah.
Mr. Mays, but you know I've been doing this a long time.
Oh, yeah,
Okay,
yeah.
okay.
But
You
from
don't
the
need to-
bench, sometimes you don't pick out the bad eggs. I've seen them. Mr. Vance is not one of the bad eggs. He's one of the guys that's going to actually take.
I don't pick out the bad eggs. What do you-
No, I've seen them. I can't say anything. I can't say anything. But Mr. Vance is the person who's actually embracing the sobriety court program. And that whole program is tailored to ensure that it never happens again.
Anything you'd like to say, Mr. Beans?
Sorry.
It's still a third offense.
Yep.
I get the fact that you're delayed, but I mean, that the other ones were, I cannot, here's what I'm doing. 2 years probation. I'm gonna take you into sobriety court. I'm glad to take you into sobriety court. And then I'm going to run the terms and conditions of the attempt fleeing and elude 4 concurrent with these. You're to comply with all agreements, guidelines, and requirements as indicated in the sobriety court participant handbook. 24 months probation. You're not to leave the state without the consent of the court. You're not to violate any law. Change your address, your place of employment, or home telephone number. You must notify probation. You have to report as directed. No alcohol, no marijuana, no illegal drugs. You're not to go any place that frequent any place that sells or dispenses alcohol as its primary source of business. I'm not going to violate you if you walk into a 7-Eleven, but if you go into a bar, that's a different story. You submit to chemical testing, PBTs and ETGs on demand of the probation officer and the sobriety court judge. You're to complete 60 more days on the sober link. You to attend AA meetings 3 times a week and provide written proof of attendance. You're to obtain an AA 12-step sponsor, attend all substance abuse treatment at a facility approved by probation. You're to attend the Victims Impact Family. You're to attend and complete the Armed Specialty Court weekend program. You're to report the sobriety court status review hearings with me every 2 weeks. You're to obtain and maintain employment with proof provided to the probation officer. You are to pay, and by the way, they insist in this plea agreement of 500 costs. Fines of 200, costs 500, 75 victims' rights fee, $50 justice assessment. So far, you're up to 8.25. You have probation fees of $480, bringing your total to $1,305. You have $360 in sobriety court fees. Stay with me on this one, Heather, will you please? $1,665. You have screening fee of $60 for $1,725. I'm ordering 18 days jail. I'm giving you credit for 1 day served. I'm going to order that you serve 5 now, that you serve 6 days on the court work program, and that you serve 6 days of community service. So it's 5 days jail, 6 court work, and 6 days community service. I'm going to give you, because you're going to be busy. So community service, I'm going to give you all the way to be completed by, I'm going to say January the 5th of 27. We're going to schedule you for your 6 days on the court work program. There's a $35 a day charge for that, bringing the total there to $210. So I'm going to have to add these again, Heather, if you I think it was, I was at. I think it's $1,935.
That's correct, Judge.
1935. You have 21 days to appeal, 14 days to apply for a court-appointed lawyer for purposes of appeal. You understand all that? And you understand that if you violate, you could get 1 year in jail on this, correct? With credit for 1 day served. And then on the attempt, flee, and elude, I'm going to simply run all terms and conditions concurrent, all the fees I'm imposing on the other case. So there won't be probation fees, screening fees. I'm not going to assess the 75 and 50. I'm simply going to go 50 fines, 150 in costs, $200, all terms concurrent with the OWI. So you're with the OWI second with high BAC. So you're in custody for 5 days. You'll do 6 days court work, 6 days community service. Any questions? Does he have all this to pay?
A report date for the jail?
Nah, he's gonna go today. He's gonna
He's
go.
got some things on.
What do you have today?
weekend.
I also play music for extra money, and I have a private party in Roseau
When?
on Saturday.
Where?
Actually, not Roseau, Gibraltar, I'm sorry, Horse Island,
Where?
house,
You're hired to do that?
yes.
Okay, I'll let you report on Monday, okay? He's to report on Monday, and I'm not gonna be here, Heather, so you're gonna have to fill out, we're gonna have to get the, maybe Judge Hessen can sign it. Report date will be, that'll be August the 10th, okay?
Okay, and you want him to report to the court or the Wayne County Jail?
Here, you're gonna report here, okay, at 8:30 in the morning. Okay? Wish you well.
Thank
Mr.
you.
Mays, have a great day.
You
Thank
too.
you. Thank you. Okay. And by the way,
Yes,
is he gonna pay all this?
you need a payment plan?
Yes.
Come on back up here. Okay, how much do you have today?
I can give you, 30 today.
300? I'll tell you what, I'm just gonna have him pay the attempt, flee, and elude today.
Okay.
That's 200. I'm gonna have him pay 100 now on the OWI second with high BAC. How much can you afford to pay, weekly or bi-weekly?
I can probably do everything online, if I pay it all in a couple of weeks.
You sure?
Yeah.
I don't want to put you in a bind with this. Balanced by, I'll say by September the 15th. If you need more time, call the court. We'll set up a payment plan, okay? Best of luck. Have a good day. Thank you.
Alrighty, friends, second session on a Tuesday. It's good to have you all here with me this afternoon. Let's do one more. It's a longer hearing, and it is with Judge Prill, and this is a motion to end a personal protection order. So let's see what's up with that.
Matter of Jennifer Turner versus Lindsey Ritter, file number 268254PH. This is a motion to terminate a personal protection order. The moving party is Ritter's in the courtroom. Ms. Turner is also in the courtroom. Would you both please raise your right hands?
Do you solemnly swear or affirm that the testimony you're about to give in this case is the truth, the whole truth, nothing but the truth, so help you God? Yes, sir.
Thank you. The court on June 25th of this year had entered a personal protection order filed by the petitioner, Ms. Turner, against Mr. Ritter. And again, that was June 25, 2026. Set to expire January 25, 2027. After the order was entered, Ms. Ritter timely filed a motion to terminate the personal protection order. And so we'll proceed in that fashion, but the understanding is, under the law, it's the petitioner's burden to establish that a personal protection order should continue. And so we'll proceed in that fashion. Also, as I understand it, there was a USB that was submitted, and the court did review that as well. Apparently it was some sort of video from inside a motor vehicle, which is court review. So, Ms. Turner, why do you believe that the personal protection order should continue?
Because of that USB drive. I mean, I had an active PPO when that was presented to me, and she was following me around with that acts.
And so this is in part a motion to find her in contempt for violation of the personal protection order. You didn't file that, correct?
What do you mean?
You didn't file a motion to have her jailed. No, you did. Here it is.
I did. I took the USB drive to the Bad Axe City PD, and they told me I had to take it up to the clerk's office. When I brought it up to the clerk's office, they told me PD should handle it. But then the clerk's office helped me. They gave me the paperwork to fill out and told me what to do with it.
So the video that's on the USB drive, whose vehicle is that in?
That is out of Miss Ritter's vehicle.
Okay. Okay. You reviewed that as well?
Yes.
So you believe that's a violation of the personal protection order? Why?
Because she was intentionally following me.
Okay. And what do you base that upon?
That she was following me. She was behind my vehicle and then going around corners to, I don't know. I didn't even know she was there until I saw that video. So. Okay.
So on the date in question that the video was made, you were going southbound on Southport Crescent, correct? Is that correct?
Yes, that is correct.
Okay, where were you going to?
I was going from my work. I work at Independent Bank. I was off for the day, but I stopped there to see my manager. Her husband, they own Thumb Auto Glass or Thumb Glass.
Which is right here on Auto Parts.
Yep, correct.
And you were to go there?
Yep, I was going there because my windshield was cracked. I was going to pull up there. I drove through the light. I was going to pull up there, but there was another truck backing out. It was kind of raining. There were other cars parked on the side of the road. I've never been there before, so I was trying to find the driveway, and I just decided to drive around the block to wait for that guy to leave so then I could pull in. So that's what I was doing that day.
So you drove past the driveway.
Mm-hmm.
You turned on what street? Would it be the first street?
I'm not familiar with Bad Axe. Yes, the first. I just drove the block and turned left.
Okay, there's a doctor's office. Used to be a church on.
I think so. Yeah.
You turned left there.
Yep, and then just drove down and turned left and came back around.
I believe the video then shows you what I call the street that's on where the park is.
The park is. Yep.
And you drove through that intersection.
Yep. Just up to the main road to go back to the light.
What color is the vehicle?
My vehicle is yellow.
Yellow. And then there's a third video where you're at the main traffic light where you were facing west.
Correct, because I was in the left turn lane.
And you were going back then to?
Yes, and then I pulled into Thumb Glass.
And your position is that the respondent was at the same intersection facing north.
She was, but all the videos show her going around to find my car.
Okay. Okay. And beside that issue, why do you believe the personal protection order should continue?
At the time when I submitted this, she was pretty aggressively following me around, driving around my house, beeping the horn, getting behind me at lunch, beeping the horn, flipping me off. I mean, when I came to submit this paperwork to the clerk's office the first time, she followed me here, and I have witnesses. I called dispatch to let them know that she was following me. But calling 911 isn't the most convenient thing, and by the time I got someone on the phone, I was literally walking out the courthouse steps, so.
Do you know of any reason why this alleged behavior is going on?
I've never met her before in my life, but as I stated, apparently she dated one of my exes for a short time and was keeping tabs on me for quite a while.
So you don't know her from Eve in any other situation? And how many times has this alleged following behavior been occurring?
It was several times. I know I noted everything in my initial statement, and then after that there was a handful of times I caught her behind me, but I couldn't get my camera up in time, but
Ms. Ritter, your response.
Is it okay if I just read my opening?
Sure, absolutely.
Your Honor, my name is Lindsey Ritter and I'm the respondent in this matter. On Friday, June 19th, my former boyfriend, Kevin Brown, broke up with me. That morning, on June 20th, early in the morning, I found his truck parked outside of a home that belonged to Jennifer Turner, his ex-girlfriend. I contacted both of them that morning trying to talk things out. Clearly, I was upset. I just got cheated on. Jennifer Turner never responded to my text, nor did she answer my calls. She never sent me a text asking me not to contact her. We never had a conversation. I blocked her number the next day and I thought things subsided. Almost a week later, I got served with a personal protection order against Miss Jennifer Turner. I was absolutely appalled and in disgust with some of the statements that I was reading and knew that I wasn't going to let this woman try to take my rights away from me over hearsay and false allegations because she is upset that I found out about a situation I wasn't supposed to. The evidence that I bring forward today will show that the petitioner's statements are factually incorrect and fail to meet the legal standard for a personal protection order. Ms. Jennifer Turner has not met the required burden of proof, and the claims presented in her request lack the specific factual support needed to sustain a personal protection order. Today, I will present time cards, photo evidence from security cameras, dash cam footage from my vehicle, and a witness testimony that will contradict the petitioner's allegations. The petitioner wants you to believe I have committed a crime, but the evidence presented today will tell a different story. This case is not about assumptions or hearsay. It is about facts that will prove that there was no threat, stalking behavior, or harassment, and that this order should be dismissed.
All right. Do you have any other witnesses you wish to call?
yeah, Kevin Brown.
Mr. Brown, would you please step up to the witness stand? Or being seated, please raise your right hand.
You solemnly swear or affirm that the testimony you're about to give in this case is the truth, the whole truth, nothing but the truth, so help you God.
Please be seated. Yes, sir. Sir, would you please state your name?
My name is Kevin Prill.
Yes, go ahead. You have some questions, please step to the podium and you may ask a question.
Did you witness Miss Ritter stalking me?
Yes.
And how so?
When we came to the courthouse here to file for PTOs at the same time, not just for yourself, but for myself and for my daughter as well. As I got here before you did, you came from the main lane of town, coming through this way, pulled into your parking spot on the right-hand side of the road. Miss Ritter was behind you. You had already sent me a message that she was behind you at the main light. She came behind you and was honking repeatedly as she went by. We came in, found out the paperwork we found online was not the correct paperwork, so we were in there 20 minutes, 25 minutes at the county clerk's building here so we could start filling out forms. Upon leaving, Miss Ritter was driving past us heading west. Circled around the main light, came back up at the first block and stopped there. We have pictures of her stopped there at the light. She gave us a look, threw her arms up in the air and sped off and took off like that. So I can say 100% that was undoubtedly her. I'm happy with the situation. I know you have shown me videos that you have taken sitting on your porch of Miss Ritter driving by your house, turning around in the neighbor's driveway next door, so that as she had seen you sitting on the porch waiting to video her and do that. That first night, Miss Ritter mentioned that she did contact us early in the morning. That was 1:30, 2 o'clock in the morning, something along those lines. I don't know how she got Miss Turner's phone number. It's not anything that I've been able to look up at any point in time. It's an unlisted phone number, but yet she somehow had it all ready to call her at middle of the night after midnight. You sent me several pictures of her behind you. You've texted me several times that she's been behind you, is circling your work. Yes, Ms. Ritter does live 2 blocks away from the bank where Ms. Turner works, but there's no need to be circling the bank to get to her apartment complex.
Good question.
Did I know her while you were dating her? Had we had any communication before you told me that she was doing all of this?
No.
I don't think I have any more questions. So.
Ms. Ritter?
For her,
For questions, if you have, yes.
So you're saying that you did see me drive past the courthouse, correct? The day that you and
Several
Mr.
times, yes.
Okay, did you ever get a subpoena to request this information, or do you have any of the video footage from me?
We have the pictures that were submitted to the court for the PPOs of you sitting outside.
I've never received.
I guess not those ones, because this was the
It was
day
the
that
day
we were
we
submitting.
Wait. No, I don't need to hear from petitioner, this is respondent. Go ahead, Ms. Ritter, go ahead.
So
The
you
court might
don't-
have received those because my PPO was not submitted until the next week. So I don't know.
I do not have any videos of my, or video footage or, photo evidence in any of these personal protection orders of me in front of a courthouse or my vehicle driving past a courthouse. So did you request a subpoena from the courts to get that? They do have cameras outside of the courthouse, correct?
I don't know what cameras they have. I assume they have cameras.
So did you request a subpoena to get the video footage of me driving by the courthouse that day?
No, because she had already submitted her paperwork that day.
But you are aware you can still file more paperwork after it's the first.
I'm not familiar with any of this because I don't come to court.
Okay. So you do have these photos of me outside of the courthouse,
Correct.
and you are sure it's my vehicle with my license plate?
Correct.
And it shows in those photos that my license plate clearly and me and that
No, it does not
vehicle?
show your license plate. It's the front of your vehicle.
So how are you sure that it's me in that
I
video?
witnessed you in the driver's seat.
That's all I have for questions for him right now.
Thank you. Okay, let's see if I can put this together. How do you know Ms. Ritter?
We dated for a period of time.
Okay. And obviously the dating relationship ended. When did it end?
She was at work. I sent her a message. I had dropped off all of her belongings to her apartment.
I'm just asking when.
Would have been June. I could look up the date. It was Father's Day weekend.
That's June 9th.
Father's Day weekend.
This year?
Correct. Yes, sir.
Okay. Do you have a relationship with the petitioner?
Yes.
Is it a dating relationship?
Yes, sir.
Okay. And prior to your allegations that there was some following going on at the courthouse when you filed the personal protection order, do you have any firsthand knowledge of alleged stalking or repeated contact with the petitioner by the respondent before the court date, before you appeared at the courthouse?
To file for the PPO?
Yes.
Yes, so Ms. Turner and I were in contact, and she had sent me several different videos of Ms. Ritter driving by her house, stopping and honking. We have a video, I believe all of these were turned into the Hufford Police Department.
Okay.
And so.
But you don't have firsthand knowledge.
I have one firsthand occurrence when that night she came over outside, was honking in the middle of the night, sent me videos directly on Snapchat of her standing outside my vehicle outside.
Who sent videos?
Ms. Ritter sent me videos
Of what?
of herself on the road, behind my vehicle, around my vehicle, that was parked on the road next to Ms. Turner's house.
Okay.
So she sent me those where she was frustrated. She went back to Bad Axe, contacted Bad Axe Police Department, filed a report. And the officer told her no contact either way, told me no contact either way. I continued to get contact. Miss Turner, we were still sitting at her house, and several more times throughout the night, a car that we did not see drove by honking repeatedly the exact same manner that Miss Ritter did when she was outside Miss Turner's house.
But you have no visual to indicate for sure that it was.
No, not that it was for sure, but the first occurrence obviously was because she sent me a video of her being there as she was sitting outside honking the horn.
Okay. Any questions in light of the courts? Yes. Any questions in light of the court's questions?
Yes. You said in this last video, I videoed myself honking the horn past Miss Turner's house. That's in the video that I sent you?
No, you sent me the video of you outside my vehicle, outside Miss Turner's house. But at that time, you were honking repeatedly several times before the video and after the video. Who else would be doing that at 2 o'clock in the morning?
So you've never seen me honking my horn
You look out
or
the window and could see you doing it.
you never seen me honking my horn or seen me driving past her house at all that night?
Not those extra times that you did later.
So the first time that you were claiming that I drove past her house, you did see me outside in my vehicle?
You sent me a Snapchat video of yourself being at that premises.
I was in the video myself.
You were talking in the video. You were holding your phone, talking in the video.
So you didn't see me driving past Ms. Turner's house at all? You don't have that, you didn't record that at all?
No.
If there was a vehicle outside, neither of you guys recorded a vehicle driving past honking, blaring their horn?
No.
Did you call the police and report it afterwards?
Yes.
What police department did you call?
Ugly Police Department.
And did they come and did you write a report?
They did not come.
Why did they not come?
That's a question for them.
So you called the police and they didn't come to let you write a report?
That's a question for them. They're not regularly scheduled. They don't have-
Did either of you guys get a subpoena to have that officer come in here to state that you got a phone call?
It's the standard work line.
Can you answer the question?
I don't file for subpoenas. I don't know how the court process works like you do.
How are you thinking that I know how the court process works?
You know obviously more how it works than I do.
That-
But the fact that you can ask me these
Was this
questions-
not up to you to make sure that you were ready for court, you and Ms. Turner, to make sure
I
that
am
you had
not
all your
required to
facts
be here
ready?
today. I am not required to be here today.
Why are you here then?
To make sure that everything gets on record as it should be.
That's all the questions I have.
You may step down.
Thank you, sir.
Do you have any further proofs?
There was a police report filed, with Ubley, and there was a case number. I included that in my PPO paperwork.
I didn't see that.
Okay.
I didn't see that. All right. Do you wish to call witnesses?
Yes.
Go ahead.
This would be for the violation of the PPO though that Ms. Turner is.
Okay.
Okay, so my witness is Miss Regine Allen. She's the manager of the Sunoco gas station in Bad Axe.
Miss, would you please step up to the witness stand?
Do you want me to explain why?
I do.
Okay.
Morning.
Yeah.
Please raise your right.
Do solemnly swear or affirm the testimony you're about to give in this case, the truth, the whole truth, nothing but the truth, so help you God. Yes.
Please be seated. Miss, would you please state your name for the record?
Regine Allen, I can spell that for you.
Please.
REAGYNE-ALLEN.
Go ahead. Sure. Any question?
Yeah. On June 30th at approximately 12:07 PM, you were working at the gas station that you worked at, right?
Yes.
And at 12:07 PM, you said you were outside that day, right? You had somebody training inside, you were outside doing something outside at 12:07
No,
PM?
I was giving a job interview in my office. My boss was present and I had an employee at the front end of the store.
Okay. And did anyone in your store hear any honking or any noise outside at 12:07 PM?
No.
I came to you with a subpoena and we went and looked at the camera footage for facing the road. From 12:05 to 12:10 PM on June 30th, correct?
Yes.
Did we ever see a yellow Bronco driving east or west from 12:05 to 12:10 on that day? And then is it true we could not get the video footage to save on a flash drive to turn into the court, so we had to have you come in today to testify?
Yes, I could not figure out a single way to get the video saved onto a flash drive at all. I'm very new at my job and my boss was not available to help provide me with the information to get the video saved.
That's all the questions I have for.
Questions?
No, thank you.
You're employed where again?
Sunoco gas station, the express stop across from Franklin on West here.
The old Mr. Chips?
Yes.
Okay. All right, I don't have any questions. Any objection to this witness being excused? Any objection? Your excuse as well.
Thank you. You guys have a good day.
You too. Further proofs?
So in this violation order that Ms. Turner turned in, it states that the PPO was signed and dated on June 25th and on June 30th at approximately 12:07 PM. She was on her lunch break. She was driving down 142 just before self-serve lumber. It says, and she heard somebody blowing their horn. She looked up to see me, apparently in her rear view mirror, swerving, blowing my horn, flipping her off, and then I quickly turned down a side road. This would not be possible if she wasn't even on that road between 12:05 to 12:10, driving east or west. So this is not a factual statement that she put in here for a violation.
Okay. Any response to that?
I don't know exactly what street she drove down. I'm not familiar with all the side streets in Bad Axe. I don't live here, but it was her. It might have been before the Sunoco, but I'm not gonna subpoena a bunch of businesses and upkeep.
But isn't the alleged violation
It's really for the drive that I sent in.
USB drive here,
Yes,
right here, this part of town?
that's correct.
There's two different ones in here that. she-
Yes.
Okay. All right. What do you wish regarding the personal protection order?
That it stay in place.
Your wish.
Your Honor, this case is not about protection. It is about misuse of the legal system. The petitioner has made serious claims, but claims alone are not proof. Over the course of this hearing, I've shown clear inconsistencies in their testimony, a lack of credible evidence, and motives that point toward personal gain rather than genuine fear. I respectfully ask the court to deny this petition, recognizing that the evidence, or rather the lack of it, speaks louder than any accusation.
Very well. Petitioner has a burden of persuasion to establish a motion to either terminate or modify a PPO. Some of the Pickering case, also burden of proof rests upon the petitioner if there's a violation. And the burden continues that way. And the court has considered the testimony, considered all the evidence. Clearly, a personal protection order was authorized. And after hearing the proofs on a motion to terminate, the court finds that there is insufficient evidence to terminate the personal protection order. Clearly, there was a reason for it to begin with. And from the testimony of Mr. Brown as well, there was even allegations regarding behaviors at the date the personal protection order was sought. So clearly, there's a sufficient basis to continue the PPO. Relative to the alleged violations, one of which was alleged to have occurred at the Mr. Chips, I call it Mr. Chips, the Sunoco on the east end of town in Bad Axe. There was testimony from Ms. Allen indicating that there was no video of the petitioner's vehicle in that area. However, court does take judicial notice that I don't know what camera angle it is, but clearly self-serve lumber is to the west of the Shell station. I guess it's Shell, Sunoco gas station. So it's alleged that apparently there was beeping of the horn and all that going on. I find insufficient proof to find a violation there. The second part, though, is there were 3 videos submitted to the court on a USB drive. It appears to be either a dash cam or maybe a phone being held by someone in the vehicle, where you see the petitioner's vehicle go by, actually going down Southport Crescent. Suppose, according to her testimony, she used to go to get glass repaired at Thumb Glass. There was a vehicle backing out, so she couldn't turn into the driveway. She turns left at the block where the Dr. Roston's office is, takes that to the end, to the dead end, which I would call Park Street, but that's really not Park Street. That's, I believe, South Hanselman. Takes South Hanselman north. The respondent, who apparently ran the video, was at the corner of Hanselman and West South Street. So it appears that, according to the video, petitioner's vehicle is in front, respondent is behind, petitioner goes past the Thumb Glass, turns left, respondent turns left at South Hanselman. They meet again at the intersection because you see the vehicle go by, petitioner's vehicle go by. And then there's a third video where, again, the petitioner is at the main light, and then so is the respondent. So there was a valid personal protection order at the time. And clearly, I don't know how you can chance contact each other that many times. I find a violation of the personal protection. Now, you've had your opportunity. I find a violation of the personal protection order. And it appears that this is a relationship between Mr. Brown and Ms. Ritter that's right. On the bad side, there's a bad breakup. There's now someone else in the picture, and the behaviors that are being alleged, the court finds, have been established by the proper standard. Regarding a sanction in this matter, and the court has done this before, this is not a situation where someone was physically harmed, physically threatened. However, I can understand why someone would feel apprehensive, and regarding alleged harassment, which I clearly understand. And so as a result for the sanction, it's simply this, Ms. Ritter. If you see the petitioner, if she is driving down the road in her car, don't follow her. Don't.
I went the other way in that video.
Don't associate with her. But there were 3 encounters.
I went the opposite way each time.
I understand.
And went to the sheriff's department
Again,
after.
you've had the opportunity to speak.
Yes, sir.
I found a violation of the personal protection order. I'm not going to issue a sanction. But what I'm telling you is, drop this relationship.
Absolutely. I already have.
He is clearly in a different relationship. Look elsewhere. On the same side, I don't want any fueling of the fire here by anyone. Just mind what the personal protection order calls for. Stay away from each other, and we'll leave it at that. That's all. I wish you all the best. Personal protection order remains. No other sanctions will be imposed. You're free to go.
Thank you.
You two go first.
And there you have it, my friends. That is second session for today. But fear not, we're not done with our programming here at TCF. We'll be back tonight, 8 p.m. Eastern, 5 p.m. Pacific for Sidebar. So do join us for that. And we'll have the full slate of programming for you tomorrow as well. Thanks for joining me this afternoon. I hope you enjoyed the show. We'll see you in a few hours. Take care. God bless.